Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, law offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. So, we received an interesting inquiry here on our YouTube channel. This has to do with somebody who got accused of theft during a protest. Let's see. I have an open case of domestic violence with my ex-girlfriend. In a protest, a friend gave me some items that he had taken from a store. In the end, I was arrested. Well, yeah. So first of all, I want to talk about that open domestic violence case. Open in what sense? Are you still going to court? Are you still fighting the case? Have you been convicted of the case and you're on probation? It matters. If the case was open and you get charged with this new offense, it is possible that you could be held without bail after being arrested because the charge would be a felony, possession of stolen property under Penal Code Section 496, which carries up to 3 years state prison. And you could be held and without bail, and you may have to essentially handle your case while you're in custody until it's resolved. Now, let's say you're on probation for your domestic violence case. Okay, that's an additional problem because if you're on probation, then this would be a violation of probation and you could be facing up to the maximum punishment for your domestic violence case simply by violating your probation. And domestic violence is something that could be charged as a misdemeanor or a felony depending on any damage the victim may have had. If there was no damages, if the victim was simply pushed or spat on or something like that, that would be a misdemeanor domestic violence under Penal Code Section 243 (E)(1), which carries up to 1 year in county jail. But if the victim suffered any kind of traumatic injury, cuts, bruises, scratches, anything like that, that would be a violation of Penal Code Section 273.5. Here in the state of California, that carries up to 4 years in state prison. So if you violate the terms of your probation, you'd be looking at those potential times depending on what you were charged with originally for the domestic violence. Now, going back to the possession of stolen property, see, in this situation, you didn't actually have to be the person who stole the items. If you knew that the items were stolen, or if the DA can show that a reasonable person in the same circumstance would have believed the items to have been stolen, you would be able to be charged and convicted of a violation of Penal Code Section 496. It's not necessary for you to have actually stolen the items. Simply being in possession of stolen items would be enough for the DA to file those charges. And if you were found red-handed with the items, that's going to be a hard pill to swallow right there. Regardless, if you'd like to learn more about criminal defense, don't forget to subscribe to our channel, law offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. But if you've been accused of a crime and need representation in court here in the San Francisco Bay Area, call us now for a free consultation at 1-800-862-7677. Criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers, criminal attorney, criminal attorneys, DUI attorney, DUI attorney.